That's her right there. She's behind
I got two trials.
you. You have two clients.
Oh,
You
I
have
thought
Darcy
trial-
and Mitchell.
Darcy and Mitchell was announcement.
Yeah. Mitchell's
Yeah,
enough.
that's actually if you was ready, that's what I was asking. This is cause number 25CCCR 1876. That case of Styles, State of Texas versus Daniela Mitchell. Miss Mitchell, is that your full name?
Yes,
How are you doing, Miss Mitchell?
I'm blessed.
You can't be better than being blessed. Now, Miss Mitchell, you are represented by your attorney Langston Adams. Mr. Adams, how are you doing?
I'm doing well, Judge.
And the state is represented in this case by attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You're welcome. Now, Mr. Adams, what is your, oops, let me do this here. Mr. Adams, what is your announcement in Miss Mitchell's case?
We need an offer on her case.
So the state hadn't made an offer to you?
Well, my email correspondence on the 25th said that they had not gotten a chance to speak with their complainant. And
Witness.
there's no offer at this time, and that was on September 25 from Miss Haley. That's the email I got
Okay.
on her
Yes.
case. And this is an assault, so Miss Mitchell is accused of assaulting another woman.
Yeah,
And that's one of the things. Now, I did get the discovery and I pulled the discovery on her case. So I know a little bit more. I got all that done.
okay.
But with her being accused, being accused of an assault, and this appears to be a fight that she had with another lady, I would want them to give me an offer, and that's
Yeah, but they have to, I think by law, they're required to contact the complaining witness now before
Yeah.
they make an offer.
Was at the same conference as you,
Right,
right? And look, the judge has to inquire before he accepts the
Right.
plea whether or not they contacted the
right. So,
As far as that's concerned, yes, I am up to speed on her case, and I got the discovery on her case.
okay, so have y'all contacted the complaining witness?
Your Honor, this is Miss Simmons' case and she's
Oh,
out sick, so I don't
that's
know.
The prosecutor. Okay, so what we'll do, we get this case a standard reset
That'll work.
Monday or Wednesday?
Yeah.
Let's do it Wednesday.
Wednesday, okay.
Wednesday be better. That'll be much better.
She's gonna give us the date.
I think it's 24.
December 17th.
December 17th? Okay, this case will be reset to December 17th, 2025. Ms. Mitchell, you can get your reset from our court coordinator. Once you get your reset, you're free to go. Stay in contact with your attorney and your bondsman, and you have a blessed day. Court is in session and calls numbers 25 CCCR 0550 and calls number 25 CCCR 0551. Both cases are styled the state of Texas versus Edwin Johns Darcy. I know they have it in here as Johns, but your middle name is what? John?
Yes.
Okay. How are you doing, Mr. Darcy? That's good. And Mr. Darcy, you're representing the case by your attorney, Langston Adams, and the state is represented in this case by attorney, well, in these cases, by attorney Shane Hilton. And Mr. Adams, I have before me a motion, the state's first motion for continuance that was filed by the state. And have you received a copy of this motion?
Yes,
And you have any objections to
Yes.
the motion?
yes, this case was specially set, because we set it specially for a Friday. Normally, I don't show up to court for a bench trial on Friday at 10 o'clock. We were specifically set today at 10 o'clock. I mean, you don't normally set cases at 10 o'clock on a Friday. So with this case being specifically specially set, and then when you look at the contents of the motion in particular, it says that DeMarcus Bernstein is a peace officer, and that his witness was necessary, and that he was notified, or the office was notified, I guess, 2 days ago, and that the district attorney's office has made due diligence and sent out trial letters in the case, and correspondence was received about his unavailability. At least that's what I read in the motion. And I'm looking at paragraph 2. If you see paragraph 2?
Where did it say he was notified 2 days ago?
Well, it was saying that I got this. Look at the date it was filed, 10/22. Today is 10.
No, that's when it was filed. Okay,
Right.
I thought you said he
That's
was
when-
notified
Well,
2 days ago. I don't think the motion specifically said when he was notified. They just said he was notified by their office
right.
of the trial, and he told them that he's unavailable for the trial week of October 23rd, 2025.
Right, and I guess my point in raising that is that there's nowhere in the code of criminal procedure that talks about trial letters. That doesn't exist. At the end of the day, like in our last case that we had, that I ended up giving them continuance for, I had the police officer under subpoena, and that police officer would have been required to be in here. There's no such thing as a trial letter notice in the code of criminal procedure. So at the end of the day, they can't say they exercise due diligence to get their witness here if you don't send a subpoena. Due diligence is, we went to the police department on October the 1st. He wasn't there. We showed up again on October the 3rd. He wasn't there. We showed up again that's due diligence to get a witness, but it's not due diligence to send a trial letter. If he was under subpoena, then he would have to be here. Since there was no subpoenas issued at all, since we're especially set on this particular case, we're ready to go.
State.
And
The code of criminal procedure just says that due diligence, it doesn't define due diligence as requiring a subpoena. We sent the letters to the officer notifying him of the date, and he responded to us that he was not available. So we did due diligence in contacting the witness to see if he was available, and he's not available. And therefore, under the code of criminal procedure, the state is entitled to the first continuance to procure their witnesses there. And there's no requirement that a subpoena is what is meant by due diligence.
well, actually, it would be an affidavit that would be attached, and we don't have an affidavit attached as to, all we saying is that he's not here. Why he's not here? I mean, is he not here because he's in the hospital, or is he not here because he decided to go on vacation? Is he not here because he decided to go and have a picnic with his kid? That's not in this motion. And at the end of the day, when in terms of due diligence to get a person before your court, the code of criminal procedure gives you one option to do so. That's by way of a subpoena. Now, it's a tactical reason that the state chooses not to subpoena their witnesses, because under the code, once that subpoena is issued and served, it benefits to the defense as well. They have the privilege of just picking up the phone and calling the police department and say, hey, come over. So they choose not to issue subpoenas. But at the end of the day, it would be different if this was, I would totally agree with you, Judge, if this was your normal trial docket and you came in here and you told me we had about 10 cases on the trial docket and you're going to tell us which one is going to go and we come pick a jury in the morning. That's not what we have here. What we have here is a case that was specially set. You specially set this case. You told us to be ready. So I'm asking the court to do what the court said. You told us that we were specially set for today at 10 o'clock on a Friday, and we would be moving Friday. That's what you told us. So at the end of the day, if the state chose not to subpoena its witnesses, that's on them. And there's nothing in the Code of Criminal Procedure that says if I file a first motion for continuance, it'd be granted. We're specially set. Since we're specially set, and the court told us we would be specially set, I'm just asking the court to honor what the court said. Then on top of that, Judge, by the very fact that there's no affidavit attached to this subpoena, there's nothing telling us why he's not here other than, hey, I can't make it. So my client is here, I'm here, the state is here. I asked the state to call the first witness, and to me, that's what's fair. You know, this is not a normal trial docket. We were specially set to be here Friday at 10 o'clock. And this motion was filed on the 22nd. Today is the what? 23rd. I mean, so how long did the state know that he was unavailable? The state made no efforts to subpoena him at all. None. Zero. So then you can't turn around and say we exercise due diligence to get him here. No, a trial letter is not due diligence. And if he has a case that he want to point to where it says from the Court of Criminal Appeals that, hey, sending a trial letter is due diligence to get your subpoena here, to get your witness here, educate me. That'd be the first case I read. That case does not exist. We have a means to procure our witnesses, and that means is by way of subpoena. And that's what I did in our last trial setting. And then even though I had him subpoenaed, I agreed to the reset. But that's not what we have right here.
Okay, Mr. Hilton, you have a response?
Your Honor, again, the Code of Criminal Procedure does not specify that a subpoena is required for due diligence. And again, the state made due diligence. They've contacted the officer, let him know of this date, and he was informed us that he was unavailable. And again, under 2904, it shall be sufficient for the state on their first motion for continuance. That means that the state should have the ability to reset the case to procure their witnesses, and that's what we're asking the court for today.
Okay. Now, 29.04 Texas Code of Criminal Procedure, it's titled First Motion by State. It states, it shall be sufficient upon first motion by the state for a continuance if the same be for the want of witness to state, number one, the name of the witness and his residence, if known, or that his residence is unknown. Two, the diligence which has been used to procure his attendance, and it shall not be considered sufficient diligence to have cause to be issued or to have applied for a subpoena in cases where the law authorized an attachment to issue. And three, the testimony of the witness is believed by the applicant to be material for the state. Okay, so
Correct, Judge. If you look at 2, they made no effort to subpoena their witness. You have no diligence at all.
yeah, but I mean, if you read it, 2, it says that the diligence which have been used to procure his attendance, and it shall not be considered sufficient diligence to have cause to be issued or to have applied for a subpoena. Okay, so they're saying that it's not due diligence if you applied for or you issued a subpoena in cases where law authorized an attachment to issue.
Correct. So if.
So if the law authorized an attachment to be issued, a subpoena is not sufficient. Or
Correct.
if you apply for, or if you have issued a
Correct.
subpoena, right?
So you don't get to the third part, which is the attachment. You don't even get there unless the person is subpoenaed.
What
because you-
attachment is, I think what the law is saying is that if an attachment is required, a subpoena is not due diligence.
Right, but in this case, you
Well,
don't have
we-
a requirement for an attachment.
Right.
You
So
get that.
attachment, right.
Right. So I'm saying the way I read that is that to get to due diligence, you got to make efforts to subpoena your witness. And this is
So
not a case.
I think what if you just read like 2, it says that the diligence which has been issued, which has been used. So they have to make a showing of what diligence they use to procure the person's presence.
What hadn't been done. Then.
And it shall be considered sufficient diligence to have cause to be issued. Well, it shall not be considered sufficient is to be caused the issued or applied for a subpoena. So
But-
the question is, you're saying
That
that
hadn't been done.
the fact that they sent a letter is not sufficient to show due diligence.
But even more than that, it's not evidence because 1, the motion isn't verified. 2, the letter should have been attached as an exhibit to the. You have no evidence that they actually sent a letter. In other words, if they're the proponent of the motion, then they should have attached their due diligence effort, which is providing that letter. And that letter was not attached to this as an exhibit. You don't have it as evidence before you. You don't have it. Because think about it for a second. If you file a motion for, it's too late now at this point, but
Well, I don't think they said that the letter had to be attached. The only thing they had to say is in the motion is what due diligence they use to procure his presence. They don't say anything about that it's necessary to attach a letter. Only thing they said that what needs to be in the motion, it says it shall be sufficient upon the first motion by the state for continuance if the same be for the want of a witness, and it is for a want of a witness to state. Then we talk about stating that in the motion. The name of the witness and his residence, if known, or that his residence is unknown, and 2, the diligence which has been used to procure the attendance. And then it's a colon behind that. So they have to state that in the motion. The diligence which has been used to procure his motion. They stated that in the motion. But now, but you saying that whatever they stated in the motion is not sufficient. That's your.
which
Okay.
is that you got to try to subpoena. And at the end of the day, the Code of Criminal Procedure gives you a specific way to procure a witness to come to court, and that is by way of subpoena. And in this case, by the state's own admission, they did make no efforts to subpoena their witness, which is compulsory to come to court. And there is nothing in the Code of Criminal Procedure that talks about what? The trial letters. You can't read that whole Code of Criminal Procedure and say, send a trial letter to get a witness come to court. Because at the end of the day, even as a witness, if I get your trial letter, I can take your trial letter and rip it up and throw it in the trash, because that does not in any way compel me to come to court. A subpoena does. So at the end of the day, to say we sent a trial letter is not sufficient due diligence at all. It is not. But and it's a tactical reason, and I gave you the reason why the state does that. And the tactical reason is that once they subpoena that officer, I get the right. They can't release him from the subpoena because I have a right to call him too. So what they do is pick up the phone, call somebody at the PD and say, hey, come on over. That's not sufficient diligence at all. That's not. It is not.
Okay.
And since they want to use that as a tactic, then you can't have it on both ways. You can't have it when the tactic benefits you, where the defense, there's no defense lawyer that can sit up here and call the chief of police and say, hey, go get your witness over here. We got to subpoena them. They can pick up the phone and call the chief of police. So in this case, since it is not working in their advantage, you can't use that both ways. That is not sufficient diligence at all. Sufficient diligence, in my opinion, is use of subpoena. Then let's say for the sake of the conversation, the proper procedure would have been this. Let's say for the sake of the conversation, he had served his subpoena on police officer Burstein, right? And Burstein had already paid for a conference in New York City, and he's out $5,000. The proper thing before today is file a motion to quash my subpoena and quash the subpoena on the grounds that the police officer would be where? In New York City. That would be the proper motion to do. File a motion to quash and file a motion for a continuance because he's going to be in New York City. You have no efforts at all to subpoena the officer, and you don't even know why the officer's not even here. You don't know if he's there to have a picnic. You don't know if he want to go to the club and have a drink. You don't know if he's with his family. You don't know none of that. So at the end of the day, since this case was specially set, like I said, if it was a normal setting where we just appeared on your normal trial docket and you had 10 other cases, then I follow the logic. But we were specially set. So being specially set, that's not no due diligence there. None.
Mr. Hilton?
Your Honor, again, the Code of Criminal Procedure provides the means. Mr. Adams creates a whole different set of rules that we're supposed to follow. It gives in the Code of Criminal Procedure what we're supposed to do to get a motion for continuance on the state's first motion. We've done that. We've done our due diligence. We've contacted the officer, and he's not available. And so we would ask the court to grant the motion.
Okay, so hold on a minute.
Why is that? You don't even know why.
You have anything else?
No, Your Honor.
Okay, so at this time, the court is going to take this matter under advisement.
All right,
Okay.
well, Judge, that's on the first case. Then we ready to go on the second case right now. It's two cases.
Yeah, he got both cause numbers on the motion.
Well, no, he put nothing that he's not ready on the other one. I didn't see that. Maybe I overlooked it. What did he mention about the other
It's
case?
the same thing. He got the two cause numbers on one motion.
Right, but-
So to
but-
me, that applies to both cases. Is that correct?
But
Dave?
Monte wouldn't be the police officer on both cases.
I don't know. That's what, he
You
had
saying-
two
you
numbers
saying
on these.
Monte's on both cases? I don't think he's saying that.
Both cases are on the motion for continuance.
No.
But is this the same witness?
No, not for both cases, is it? Burst Monte, Burst.
Oh, you don't have to.
So,
It's not. He's
Oh,
not
okay.
even on the other
So-
case. So he's not even on the other case. So how
Oh.
you say that he's needed for other case?
Yeah, okay, well,
He's not even on the other case at all.
okay. Well, I didn't
So-
know,
So if they not ready for one, they need to be
Your Honor,
ready
it
for
all came
all.
out of the same criminal episode. It's all the same incident.
okay, hold on a minute. Let me see.
Uh-huh.
Hold on a minute.
You see,
It's the same call, it's the same offense date.
yeah, it is the same offense. You got the failure to identify and you got the assault family member. But on the assault family member, what he would need is the complaining witness. He doesn't need a
Oh,
police officer for that.
Yeah, I don't know who his witnesses are. I don't know.
No, I'm just saying on an assault, nobody's saying the police officer was assaulted. His witness on an assault is the complaining witness. So he can have a case. He don't need First Monte for that case.
Is that,
If I
oh, yeah,
assault
I mean,
you are
I don't know.
complaining,
I don't
not
know who
the
his
police
witness,
officer.
okay, who are your witnesses on,
His witness,
on,
it would be
on the, assault case? Who are your witnesses? Do you,
It would
did,
be,
did he give you a list of witnesses? Was it in the discovery or?
I'm telling you, the
Your Honor, we can prove an assault without the complaining witness. I mean, we don't have to have the complaining witness. If there's other ways to prove up the assault, I mean, cases proceed all,
We're not
there's
talking,
not a victim on a murder case, and yet those proceed.
yeah, no, but
So
we're not
Officer
talking
Bernstein
about,
is a
not-
necessary witness on the assault case.
okay.
So
Oh, you said two different things.
okay.
One was that you didn't need a complaining witness on the assault case. And then you saying, that's what you first said,
yes,
that you can prove it up without a complaining witness.
Because he
And then
said
you
we
can't
had
be-
to have the complaining witness. That was our only witness that we could have on the assault and then address.
Yeah,
that
you know,
and say
no,
that's not a true
but the
statement.
issue is Bernstein a necessary witness? That's the issue in this assault case.
He's not.
And I'd say he is, yeah.
Oh, well, I don't know your, okay. Let me do this here like you have anything else?
No, Your Honor.
Okay. So at this time, the court is gonna just take this matter under advisement. We have a couple other things to take care. Y'all can just have a seat. Okay, we could go off the record.
That's why
Jefferson County Court at Law number 2 is in session. The court is in session and cause number 25 CCCR 0698. Case is Styles of State of Texas versus Rainey D. Prudham. Ms. Prudham, is that your full name?
The D is the shade.
The shape? Okay. Now, Ms. Prudham, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth shall help you God?
Mm.
Ms. Prudham, you may put your hand down. And Ms. Prudham, how are you doing again?
Okay.
I'm doing fine. Thanks for asking. Ms. Prudham, you're represented in your case by your attorney, Attorney Joel Vasquez. Attorney Vasquez, do you waive a record in Ms. Prudham's case?
Yeah, sure.
And Ms. Prudham, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Rainey D. Prudham, on or about February 5th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Ms. Prudham, do you understand what you have been charged with? To this charge, Ms. Prudham, how do you plead guilty, not guilty, or no contest? No contest. Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, Ms. Prudham, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Ms. Prudham, do you recognize this document? Now, Ms. Prudham, on page 2 of this same document, there are a set of initials, RP, on a line next to a box that says check nolo contendere, which means no contest. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Ms. Prudham, I also have a document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Ms. Prudham, before you signed and initialed all of these documents that I've just showed you, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Ms. Prudham, are you a citizen of the United States?
State Office States Exhibit 1.
Any objections?
No.
No objections. State's Exhibit Number 1 will be admitted. Mr. Vasquez, you have observed and counseled Ms. Prudham. Is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
And Ms. Prudham, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Ms. Prudham, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Okay, State, do we have a plea bargain agreement in this case?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 90 days county jail to be probated for a period of 1 year of community supervision at a fine of $250, repayment of court costs, and 40 hours of community service. And Ms. Prudham has 2 days of credit to go towards her fine and court costs.
Thank you, Chief. Ms. Vasquez, were you appointed in this case?
Yeah, sure.
What's the court cause?
It's 77.
Mr. Gurr.
Yeah.
Langston said this was delivered by the mailman, or something, whatever it is. Was that for us, the court, or one of the courtrooms? Two.
I'm not trying this way to do. I'll check.
Okay.
No ticket in.
Let's see, 17. Okay. Ms. Prudham, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be on probation for a period of 1 year. During the 1 year probationary period, you will be required to pay a fine of $250 plus court costs of $277. You will also be required to pay a probation fee of $60 a month, urinalysis fee of $15 a month, and a reimbursement fee $15. Now, you'll also be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is, the total amount that you will be required to pay each month while you are on probation is $163 a month. Will you be able to pay the $163 each month?
Yes.
You'll also be required to perform 40 hours of community service. What? Let me do this here. Messed up. I was supposed to give you, you also will get 2 days credit towards your fine and court costs. So let's do this here. It's gonna be 15. So that's gonna reduce the amount that you would have to pay for each month, that you would have to pay each month. Okay, let's see, so. So instead of paying $163 a month, you'll be paying $145 a month. Okay, will you be able to pay the $145 each month? All right. You will also be required to let me take out that. You'll also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Ms. Prudhomme, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer? Ms. Prudhomme, I'll follow the plea bargaining agreement that you made with the state. Now, Ms. Prudhomme, this will conclude this case. Please have a seat in that first chair on the wall and wait for your name to be called. Okay?
Thank you, Judge.
Okay, you're welcome. And Mr. Vasquez, you're free to go. And you have a blessed day.
Thank you, Judge, and thank you for the appointment
Okay,
yesterday.
no problem. All right.
In the deal.
All right. Okay. We'll be in recess. Court is back in session and cause numbers 25 CCCR 0550 and cause number 25 CCCR 0551. Both cases are styled the state of Texas versus Edward John Darcy. Mr. Darcy is represented by attorney Langston Adams. The state in this case is represented by attorney Shane Hilton. The state has previously filed a motion for continuance in these cases. And the court previously heard arguments from both the state and the defense. And the court took this matter under advisement prior to the court's making a ruling. Mr. Adams had an additional argument. And Mr.
Yes.
Adams, is that correct?
Correct. And it's actually a two-part argument. Looking at, and I'm reading specifically 2904, the first requirement isn't met, which is the name of the witness and his residence, if known, that his residence is unknown. That's a requirement for the motion. In their motion, they do not list the residence of their witness. That does not even exist. That doesn't appear in the motion. And then they do not even state whether or not the residence is known or unknown. So just as a requirement of the motion itself, that doesn't exist. But then the second part, remember when I said that I lowered the standard when I shouldn't have lowered the standard for my own argument? The reason why I say that is that if you look at the second part, the diligence which has been used to procure his attendance, and it shall not be considered, that's what you were saying earlier, it shall not be considered sufficient diligence to have cause to be issued or have applied for a subpoena. So hit pause right there before you go to the next thing. Even if they would have applied for a subpoena, just that is not enough to establish due diligence. But what you have in this case is they didn't even try for subpoena. They lowered for themselves of getting to due diligence, because the code is saying, hey, for you to be diligent, you should be trying to get a subpoena. But even if you get the subpoena, in and of itself, that's not enough. You got to show the other due diligence you made. Well, in this particular case, they never even got a subpoena. They never made an effort to get a subpoena even in the first place. And so what I'm saying to you is that on the first standard, they can't meet because they didn't put in motion the residence of the officer. And then on the second motion, if you take on the second element, I should say, if you read it directly, even trying to get a subpoena is not sufficient diligence. But in this particular case, they didn't even try to get a subpoena. And getting a subpoena is an effort toward due diligence, but you need to do something else. And the something else we don't even get to because they made no effort to even get the subpoena. So what I'm saying to you is, as a matter, just like in a civil case, summary judgment goes to matters of law. As a matter of law, one, procedurally, they did not tell you the residence of the officer, and that's in here, and they didn't tell you in the motion that the residence is unknown. But more importantly, securing a subpoena to me is an introductory base level effort, but they got to go beyond that. So so as you said earlier, that the argument as it goes to was your due diligence sufficient, then I'm going to say if you take 2904 and just read it as is, it's no way to even get to that. It's impossible. And then as it relates to the other case, the material witness in the other case, which would be the complainant, she's not mentioned at all. So what I'm saying is that as a matter of law, the motion would be insufficient for the court to grant this motion for continuance. It'd be absolutely insufficient.
Okay, Mr. Hilton.
Your Honor, the motion for continuance provides the location of the Port Arthur Police Department because this police officer acting in his role as a police officer and as an agent of the Port Arthur Police Department. That would be the address that he served at. And then we would still maintain our position that the due diligence was met when we sent a letter to the officer, made contact with him, told him about the court date, and he addressed that he was not available. We still think that requirement has been met.
Judge, just,
And-
I'm sorry, I don't want to work.
Oh, okay.
I don't want to work, my bad. Judge,
And that's on for cause number 25CCCR0550. On the second case, 25CCCR0551, the state is prepared to announce ready and proceed on that matter today. That's the false identification
Okay,
charge.
so you're already on 25CCCR 2551.
0551, I believe.
Okay,
well, and my response is that the Port Arthur Police Department is not a residence. And if you look at the statute and you read it word, it says residence, so they're
okay,
residents.
okay,
not-
okay, but they say they're ready on 25CCCR or 0551.
And which one is that one?
The failed to identify giving false
Well,
information.
that's I'm sorry, Bernstein, so he is available then.
No, it's not Bernstein, that's Blake.
Well.
Oh, okay, so
Well, you
that,
understand, let's go.
okay, so that motion,
They withdraw.
okay, so they're withdrawing it on 5-1.
Yes, Your Honor.
Okay,
We'll call you first witness, we said it.
okay, hold on, let's do this here. Y'all could just have a seat. Once we get these other matters taken care of, we'll get started on the trial.
Yeah, there's no need, no opening, we start 10 o'clock. Good.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 1328. Case is styled the state of Texas versus Terry D. Prudhomme. Mr. Prudhomme, is that your full name?
Yes, sir.
Mr. Prudhomme, would you please raise your right hand? Mr. Prudhomme, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Prudhomme, you may put your hand down. How are you doing, Mr. Prudhomme?
Fine.
That's good. Mr. Prudhomme, you're representing your case by your attorney, Attorney David Grove. Mr. Grove, how are you doing?
Real good, Judge. Thank you.
That's good. Now, Mr. Grove, do you waive a record in Mr. Prudhomme's case?
Yes, sir.
Mr. Prudhomme, I have before me on my computer a document that is titled Information. This information alleges that you, Terry D. Prudhomme, on or about March 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive from justice.
Yes, sir.
Mr. Prudhomme, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Prudhomme, how do you plead?
No
Guilty?
contest.
Are you pleading no contest? Now, Mr. Prudhomme, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Prudhomme, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, TDP, on a line next to a box that's checked no contiguous, which means no contest. Did you place your initials on this
Yes,
document?
sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that is titled Trial Court Certified Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 1820. The case is styled the state of Texas versus Giovante Malik Howard. Mr. Howard, is that your full name? Mr. Howard, would you please raise your right hand? Mr. Howard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Howard, you may put your hand down. How are you doing, Mr. Howard? That's good. Mr. Howard, you're represented in your case by your attorney, Attorney Giles Cole. And Mr. Cole, how are you doing?
Great, Judge. How about yourself?
I'm doing fine. Thanks for asking. Mr. Howard, Mr. Cole, do you waive a record in Mr. Howard's case?
Yes, sir.
Mr. Howard, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Giovante Malik Howard, on or about April 11 of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana, less than 2 ounces. Mr. Howard, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Howard, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document? On page 2 of this document, there's a set of initials, GH, on a line next to a box that says check, no contingent, which means no contest. Place your initials on this document. On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. Howard, before you sign and initial these documents, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? And Mr. Howard, are you a citizen of the United States?
State offer States Exhibit 1.
No objections. States Exhibit number 1 will be admitted. Mr. Cole, you've advised and counseled Mr. Howard. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Howard, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation? And Mr. Howard, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 9 months of deferred adjudication, fine of $250 with repayment of court costs and 24 hours of community service. And Mr. Howard has 2 days jail credit to go towards his fine and court costs.
Okay, 2 days, right? What's the court cost?
2 seconds.
Okay, 277. And Mr. Cole, you were a partner?
Yes, Your Honor.
Okay. Mr. Howard, the state is offering that you serve 9 months to further adjudicated probation. During the non-probationary period, you will be required to pay a fine of $250 plus court costs of $277, which comes to a total of $527. You will be given credit for 2 days that you've served in the county jail. And so instead of paying the 527, it'll be 327. It'll be reduced by $200. You'll also be required to pay a probation fee of $60 a month. Your announcement of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Code Appointed attorney's fees of $350. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $171 a month. Will you be able to pay the $171 each month? You will. You will also be required to perform 24 hours of community service and adhere to the other standard terms and conditions of this probation. Now, Mr. Howard, do you understand the state's offer?
Okay.
Do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
Yeah.
Mr. Howard, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Howard, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Howard, you will stand next to the bailiff at that table, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day. And Mr. Cole, you're free to go and you have a blessed day.
I'll be excused, y'all.
Yes, you may. Where's
Outside.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 0551. The case is styled the state of Texas versus Edwin Johns Darcy. We have Mr. Darcy present in court with his attorney Langston Adams. And state is present with Assistant Criminal District Attorney Shane Hilton and Mr. Samuel Masradian. State, are you ready?
State's ready, Your Honor.
And defense, are you ready?
Yes, Your Honor, defense is ready.
Okay, y'all may be seated. Let me,
Your Honor, we'd like to make a trial complaint. We would like to, the information, sorry. We would like to remove the S from Edwin Johns Dorsey as written into the information. And we'd
Okay.
also like to change the officer listed as DeMarcus Bernstein to Officer Flakes.
Your Honor, object, that's a substantial change to the indictment. It's untimely. We've already been called to trial. That should have been done before trial. It's untimely. It's absolutely untimely.
okay, hold on.
And they already been off ready. So it's untimely.
Okay.
Argument is the equivalent of that is to be on the day of trial, you announce ready and you tell me your complainant is John Doe. But then after you announce ready, you all of a sudden I say my complainant is Scott Doe. That's untimely and that's way too late now. They already announced ready. They stuck with that.
Okay, now state, what's your response?
They have no law.
Yeah,
No law.
hold on.
Oh, I'm
You're not the state. Okay, state, what's your response? Ms. Mosby, could you turn those cameras around to?
Is that fine?
Mm-hmm.
You got a lot of the light, just put it down some, so we can see the. Just keep on putting it down, coming down with it. Okay,
Maybe more, like,
No, well, hold on a minute. Yeah, that's good.
Before I go
That's
down.
good.
It's making more like.
The only thing you got but on my thing, it's not showing that glare. It's just showing the glare up there. It's not showing it on my monitor, which is good. Okay, that's good. That's good. So, Mr. Hilton, what's your response?
Yes, Your Honor, David said this is not a substantial change. That the allegation is that he lied to a police officer reporting out the police department. And he's just changing which officer it was. That would be the safe position, Your Honor.
Again, Judge, he has no statute, he has no case to support that. If what is substantial is not this, I don't know what it is. He put in his charging instrument, the charging instrument that my client made a false statement to DeMarcus Bernstein. He announced ready. And then after announcing ready, he says, I'm gonna make a trial amendment and change that from DeMarcus Bernstein to a whole nother person, and the whole nother person would be Garland Flakes. If that's not material and substantial, let the whole ceiling fall down. I don't know what is. The equivalent of that would be is for you to say, Langston Adams is charged with assaulting a John Doe as the complainant. Then the state announces ready, and then during the middle of the trial, they say, okay, well, he didn't assault John Doe, he assaulted Scott Doe. That is significant. It's too late for them to make that change. They should have announced not ready. They announced ready. They're locked in. And they can't give you a case to support their position. They can't give you a statute to support their position because they're wrong. You can't do it. That is substantial. So at the end of the day, they stuck with this. And when they announced ready, they said, we are ready to go forward with proving our case. And our case is that on December 28th, 2024, did then and there intentionally give a false statement to DeMarcus Bernstein. That's what they announced ready to. So it's way untimely, and he don't have a case to support that.
Okay, Mr. Ronnie?
Your Honor, I would, first of all, like to apologize for doing this out of order. I should have made this amendment, tried to make this amendment before I announced ready. I'm new to this. I know that's not any excuse, but I would like to take some responsibility. I should have made this beforehand.
Too late.
Still time. But the important thing here is the defense has full knowledge that we weren't calling DeMarcus Bernstein for this case. We talked about this during the negotiations for the continuance, that DeMarcus Bernstein was not the crucial witness for this case. In fact, it was Garland Flakes, who has now spent time in this courtroom waiting here today. So the defense has full awareness that Officer Flakes was going to be the one to testify in this case. Therefore, they ought to know that Officer Flakes was the one that was lied to by the defendant in this case. I understand that this is a different name, but substantively, you lied to a police officer of the Port Arthur Police Department. It's a different name. The Officer Bernstein was fully involved with this case, but he didn't come to the scene where the defendant allegedly made the false statements. He was involved with the assault. Again, the state's position that this is not a substantive change, and the defense had full knowledge of Officer Flakes being called in this case, not Officer Bernstein.
Stand up and say, Judge, I'm sorry, my bad. I'm a new lawyer. I shouldn't have announced ready is not a legal argument. Standing up saying, my bad, I'm a new lawyer. I shouldn't have made this mistake. My bad is not a legal argument. Again, in terms of being legal argument, when he announced ready, he is telling the court and the whole world, I am ready to go to trial on my information. That's what he's telling the world. Then he cannot turn around and change Mr. Bernstein after announcing ready to a whole new person. And I'm telling you, there's not a case that he's going to find to support that. That's basic law school 101. Matter of fact, if he wanted to make leave, he would have filed a motion for leave to amend his charging instrument. And that should have been done pre-trial. They didn't even request a pre-trial hearings. They didn't file it in pre-trial motions, but a motion for a continuance. And what we're saying, Judge, is this. They know it would be abuse of discretion if this case went up on appeal. I'm almost 100% sure he would win. They know that it would be abuse of discretion for the court to grant a trial amendment after you announced ready. He announced ready. And at the end of the day, saying, my bad, I'm a new lawyer, that's not a legal argument. It is not. And they can't give you a case, they can't give you a statute. So what I'm asking is that you deny that, call Mr. Flakes, and if they call Mr. Flakes, they know that they can't make their case with Mr. Flakes. And again, it's not about, I apologize. It's not about my bad. It is what is legal and what is not. And legally, as a matter of law, that's untimely. Now, the correct thing, and he acknowledged, I'm gonna tell you what the correct thing to have done. Judge, we're not ready. We move that for our second request for a continuance. We looked at our charging instrument and we need time to recharge it or whatever they want to do. But that's not what they did. You said, is state ready? Yes, ready. You said defense. Is defense ready? Yes, ready. Then they turned around and say, hey, judge, let me have this trial amendment. Too late. And everybody in the courtroom, he can go to his law professor that takes criminal law and tell him it's too late. It's absolutely too late.
Okay. Any other response?
No.
Okay, now, Article 28.10, which is titled Amendment of Indictment or Information, A states, after notice to the defendant, a matter of form or substance in an indictment or information may be amended at any time before the date the trial on the merits commence. On the request of the defendant, the court shall allow the defendant not less than 10 days or a shorter period if requested by the defendant to respond to the amended indictment or information. B, a matter of form or substance in an indictment or information may also be amended after the trial on the merits commence if the defendant does not object. C, an indictment or information may not be amended over the defendant's objection as to form or substance if the amended indictment or information charges the defendant with an additional or different offense if the substantial rights of the defendant are prejudiced. So first of all, when we're looking at A, it cannot be filed on the day of trial. Today is the day of trial, okay? Let's see, B, a matter of form or substance indictment or information may also be amended after the trial on the merits commences if the defendant does not object. The defendant has objected. 2. 3, an indictment or information may not be amended over the defendant's objection as to form or substance if the amended indictment or information charges the defendant with an additional or different offense, or if the substantial rights of the defendant are prejudiced. Okay? And so we have here 2 things. One, you want to change his middle name from Johns to John. I think that's what you mentioned. And then 2, I guess in this case, the peace officer is different. You want to call a different peace officer.
Yes, Your Honor.
Okay. So the question is, even with that, that's a substantial rights of the defendant are prejudiced. So based on Article 28.10, and I'm just looking to make sure. Now, do you have a case to support your position?
Before us, Your Honor.
Okay, hold on. Just ask. I'm just asking, do you have a case to support? I just read the statute. Now, is there a different interpretation from the Texas Court of Criminal Appeals? Or do you have a Texas Court of Criminal Appeals case that supports your position? That's my question.
No,
And as I said, Judge, it doesn't exist because at the end of the day, you just read, they can't do it. And we can go to basic law school 101. It's too late. He announced ready. And when he said ready, his announcement to the world was, I'm ready to go to trial on my information. And as two said, I got a right to object. Then it's too late. So it really doesn't make a difference what Garland Flake says. He can testify all night long. He can testify for 2 hours. They still can't make the case. It won't make a difference what Mr. Flake said. And jeopardy is attached because on a bench trial, we've all announced ready.
Yeah, but I mean, the issue is, even with A, B, or C, it doesn't look like it supports the state's position,
Correct.
28.10.
And as I said, Judge, it makes no difference what the testimony of Mr. Flakes is. Flakes is not DeMarcus Bernstein. So if they want to waste the court's time with calling Mr. Flakes, let them waste the court's time. They want to waste it, they can waste it. That's on them. Flakes can say whatever he want to say. They would still lose.
Yeah.
It
So
doesn't make a difference what Flakes say.
you have a response, Mr. Maserati?
And Your Honor, I would argue that the substantial rights are not prejudiced. The statute just says giving false or fictitious information to a peace officer. We are more than capable of proving that it was a peace officer, that he gave false or fictitious information to a peace officer. The charging instrument's merely a name of form. It was somebody obviously drafted it, put the name from the assault, the peace officer from the assault case on this case as well, and that shouldn't have been done. But ultimately, I don't believe that the substantial rights are prejudiced here because we can prove he gave false or fictitious information to a peace officer.
Okay, but what is the law regarding substantial rights? Do you have a case to support your position?
Not in front of me, Your Honor, no.
Right, because it doesn't exist. He's not gonna find.
Okay, let's do this here.
Judges matter law.
Okay, hold on. Let's do this here. The court is going to just take this matter under advisement. The court is going to give each side a few minutes to do some research, see if there's anything to support either side position. Okay,
Thank you, Your Honor.
so we'll be in recess for, let's say,
I can tell you now, it don't exist. The kind of research I need to do. It don't exist, and they're not gonna find nothing exists because it doesn't exist. But
okay.
if you want to give us 5 minutes, that's fine with me.
Okay, what we'll do is we'll recess for 15. Okay, 15 minutes. Okay. Okay, Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 0551. Case is styled the state of Texas versus Edwin Johns Darcy. Let the record reflect that Mr. Darcy is present in court with his attorney, Attorney Langston Adams. Let the record also reflect that the state is present with Assistant Criminal District Attorney, Attorney Shane Hilton. Now, the state as well as defense previously announced that they were ready for trial. The state moved to amend the information. So after arguments by both the state and the defense, and after applying the facts to the law, that motion for a trial amendment is denied. And state, you may proceed.
State will waive its right to our opening statement.
Well, first of all, state, you have to read the information. Would you please read the information?
Yes, Your Honor. In the name and by the authority of the state of Texas, comes now the undersigned Assistant Criminal District Attorney in Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Edwin Johns Dorsey, hereafter styled the defendant, heretofore on or about December 28, 2024, did then and there intentionally give a false and fictitious name and date of birth to DeMarcus Bernstein, a peace officer who had lawfully detained the said defendant, and the said defendant knew that DeMarcus Bernstein was a peace officer against the peace and dignity of the state.
Okay, now, Mr. Darcy, how do you plead?
Not guilty.
Not guilty? Okay. State, would you like to make an opening statement?
We'll waive the opening statement, Your Honor.
Okay. State, would you like to call your first witness?
The state doesn't have any witnesses, Your Honor, and the state will rest.
Defense,
Defense has no witnesses. We move for instructed verdict, a directed verdict.
at this time, your motion will be granted. And Mr. Darcy, you're acquitted of this charge. Okay?
Are we going now call on the next case?
Mm.
It's gonna be reset.
And we're gonna reset the next case.
That's fine.
Thank you, Your Honor.
That's cool. Whatever y'all want. Give them whatever.
This is this is on 5-1. Yeah,
Right.
25 CCCR 0551.
And we signed the paperwork that he needed for the bench trial.
Yeah. No, there's a waiver.
Sorry.
The waiver was signed on September 24 to 2025 on both cases.
So when do y'all want to try the next one?
We have to get a date.
From her?
Just
Y'all can just send it.
we're gonna have,
Give it to you.
They just-
yeah, we'll give it to
That's
you.
fine.
okay, so you're gonna get your dismissal,
Well, not dismissal.
I mean, your acquittal
Mhm.
and your reset. Once you get your
Everybody ready to go?
yeah, you'll be free to go. You have a blessed day.
Thank you.
Okay,
Appreciate
you're
it.
welcome. And this will
Thank you.
conclude the calling of the courts.
Huh?
This will conclude the calling of the court's announcement docket and the trial on today's date in County Court at Law number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day
All right.
and have a good weekend.
Thank you.